what we're talking about earlier on of Umuthoso versus Guptas and versus Bushiri. We may be saying these are still ongoing, but the fact is that it's unlikely that Umuthoso will ever come back to this country because we released him to get out of the country. We're not getting Bushiri. Bushiri now is reviewing his own country's outcomes. In his country, we can't touch him. We allow Umuthoso to get out even when you are saying you are appealing the decision of a judge. But then he's out of here with all the crimes that he has committed, serious crimes and the violation of its young children. It's not even women. It's young children that he violated. Yet we'll sit here and be like, no, we will go to Nigeria, we'll talk to Nigeria, maybe will listen to us, unlike the Arab Emirates. We don't know that. We have no control over what Nigeria will say, will do, and what it can decide in terms of this person. And this is all happening because the National Prosecuting Authority, again, is in the middle of these cases that do not find successors. So I'm not sure what would be the best way to deal with. The NDPP should tell us, what is it that must be done in this country? Is it training that is lacking? Are these people doing their job or not doing their job? What are the assessments that are there that you carry out throughout? I'm sure there is yearly assessments for everyone. What are the assessments? Are your assessments telling you that these are the people who are fit and proper to prosecute over cases that are serious and ensure that we get successful prosecution out of that?
Oh, yeah, there was that question. Thank you, NTPP. I'll be honest with the honourable member Mente about that. I didn't investigate that before coming here. But 174 we all know is a legal process of the NPA Act. But I would like to suggest, Chair, with due respect, maybe Member Mente can give us details. But we don't get most of these cases discharged at end of state case. We are not getting any alarming signals that we are losing cases, because your 174 acquittal actually is a very, very borderline case. You know, you may want to wonder why it was enrolled.
May I ask that we, for the public, just simplify what a 174 discharge is? That when the prosecutors have presented their case and the defense makes an application to dismiss without having to present their own case? Is that it?
Yes.
That is it. Okay, yeah. No, I like to just make sure we all know what we're talking about.
Yes,
okay.
Yes. Member Mente knows about it very well. I'm joking. But it is that section 2, Chair, of the 17 of the Criminal Procedure Act, where the state leads all its evidence by state witnesses, and then the prosecutor says, I close the case with the state. And then the accused or his attorney says to the court, I apply for this accused to be discharged because none of this evidence brings a case for him to answer. And then the magistrate uses his own analysis. There are principles that apply, and then the magistrate, if he agrees with the accused, then acquits. And then it is, of course, a process that the NPA, if it feels aggrieved, can take it further. And the example is the one that is still fresh in our mind, the Nulane case, where all those accused were acquitted on 174, and there was a successful appeal. Thank you.
And not a lot. Perhaps I could just speak to the last issue regarding the 174 discharge. I also am not certain what informs that we've got a lot of Section 174. I don't know, and also I'm not certain whether it's what numbers were looked at to come to that conclusion, and whether are we talking about generally in the NPA, the 174s generally, or are we talking in this space that we're talking about now, complex corruption or commercial crime. So I'm not certain. But what I can say is that...
Could it help if you attempt to do what I asked last time? I can't remember what it was in relation to, where I say, on average, do these things succeed or not? Because I think what becomes difficult for the public is that you get a high-profile case, and in that high-profile case, the Section 174 is successful, or there is an acquittal at the end, and the judge criticizes the NPA's management of the case itself. And those things create the impression, and I think would be justified as a public to say, but these guys don't know what they're doing.
Yes, I understand that, but then it would be reckless of me to say, we don't get a lot of Section 74 when I'm not looking at anything, or give you an average. It would be very reckless of me to do that. But that's why I wanted to get clarity to say, are we talking about... on what basis is the statement made? Is it that we looked at, we don't usually report on this in the annual report, right? But I have received confirmation from our ops team that we do keep stats on, we separate them. So we have stats on Section 174s and not guilty, where the entire case happened. So I should be able next time to then give you an average, Chair, to say, and answer the member to say, stand boldly and say, our 174, Section 174 acquittals are very low, comparatively speaking, to the number of prosecutions we take. I want to be able to do that, but I can't do that without any figures in front of me. So, but I take comfort that we do make a distinction, because I was worried that because both a not guilty at the end of the trial and a 174 is the same thing, in the sense that the accused was found not guilty. So I was worried that perhaps we're lumping them together. But I have confirmation now that we do, when we keep our stats, separate them on the ICMS and the ECMS, that we can be able to give that report to, so then I can stand up and say, well, we do have a lot of 174s, or we don't have a lot of 174s. At the moment, I cannot make that statement, and
don't worry, but let's put it, so what Advocate Mzinyati with the Secretary is going to send in that same correspondence, just provide us with the stats.
Yes, I just want to speak, and I don't know if I'll be speaking out of 10 NDPP, but with regards to witness protection, right? It's understandable that in certain cases, witnesses are afraid to come to the fore and give evidence and cooperate. But when people do come in, and also the witnesses are reluctant to take up the offer of witness protection. But what I can say confidently here is that when they do take up the offer of witness protection, we have a good record, and perhaps then people can speak to that. We've got a good record in terms of witnesses who were harmed once in the program. But because it's an invasive process, you have to give up a lot of yourself and your family to be able to go into the program. A lot of witnesses are reluctant to take up the offer, but when they do take up the offer, we have a good record in terms of protecting witnesses that are in witness protection. Thank you.
Now that you're saying it, was that offer given to the witnesses in the Umutoso case? Because I know the last witness was gunned down in PE. She was a witness, and other witnesses were also eliminated in the Umutoso case. That's one, but there's the rest of them. So at what point do you offer this witness protection and protect witnesses successfully?
I won't be able to speak to the Umutoso case. It's outside my thing. But what I can speak to, and what I'm speaking to, is that once they come in, there aren't incidents. I can't speak to the Umutoso because it's not within my space. I don't know whether it was offered or not. Maybe the NDP or the NPP can speak to that. But I know that from the police, from the NPA, it's something that if we are aware that witnesses are at risk, or when risks, when they assess a case, that is offered. But I can't speak about this matter. I have no knowledge thereof. Thank you.
I don't think there were any AFU matters, or were they? Yeah, please go ahead. Chair, through you.
Just a quick one. There was a question around the good and the bad regarding the SAP and ABB, punitive reparation. Is this, restoration, restitution? What does all this mean, and what is preservation? So with all the corporate alternative dispute resolution that we've entered to, this is restitution. It's supported by UNCAC, international obligation, that we should be able to enter into these mechanisms, and UNODC and so basically it's all about making good that you unduly benefited. So so punitive reparation then becomes a fine that sub ABB McKinsey pays into this criminal asset recovery account. It's a fine. We call it punitive reparation. Over and above that, they make good to the victim or the SOE. So in ABB, money was paid back to Eskom. In SAP, it was paid back to Eskom Transnet, PRASA, City of Johannesburg. There was a lot of institution where disgorgement, the contract amount was paid back to those institutions. Then the other question quickly was, what is preservation? Preservation is similar to restraint. It's a freezing order. And preservation is non-conviction based. So we're not going to wait for the case to be, prosecuted and there's a conviction. We're going to apply for the money to be forfeited to the state, the assets to be forfeited to the state within 90 days. Hope I've captured the question correctly.
Chair, the questions.
Sorry, just quickly, there's a clarity-seeking question.
No, just one follow-up on that issue. So the matters of APP, SEP, they are currently under investigation, right? So
that is correct.
And then you enter into a dispute resolution to say this is the amount of money that we are going to pay.
That's correct.
And then that amount of money that they are going to pay, the scale of the graft or the corruption that they are accused with of, as compared to the money that they are paying, does that balance out? Maybe once the criminal prosecution is finalized, you'd find that it was at a massive scale, and you maybe only charge them 0.5 or 1% of what they took from the fiscus.
So it's the contract amount gets paid back. The entire contract amount gets paid back. So in the case of Eskom, SAP paid back 500 million back to Eskom, 344 million to the Department of Water and Sanitation, I think another 321 million back to Transnet. The entire amount of the contract is paid back, where there was additional bribes paid. So money wasn't, all these SOEs had paid, right, SAP for services, for their software. But in the process, there were people who got kickbacks on the side. So we are saying these contracts are tainted. So the entire amount gets refunded back to the institution. But over and above that, 750 million got paid. In addition to these disgorgements, it got paid into the criminal asset recovery account. That's why we call it punitive reparation. It's a fine. So the wrongdoers, the individuals, all the people who, because it's not the company that's committed the crime, it's the people in the company who were paying bribes out there, those ones are still going to be prosecuted. The investigations are ongoing.
Okay, let me try and assist here because this was explained. So I'm gonna try and just simplify it because we might be here a long time.